black men will tell me, you should just walk away from your kids. She giving you all that stress. You don't took very, and I didn't understand it at first, Judge, but now I do understand it. I understand why some men walk away, but I love my kids too much to walk away. But it's so hard. It's so hard. It feel like you're in hell actually, and I'm a Christian.
Danielle Holland representing petitioner Tristan Williams.
Thank you. And ma'am, would you please state your name for the record?
Frederica Ellison.
Okay. And Ms. Ellison, you are the respondent in this case. Is that correct?
Yes, ma'am.
Ma'am, what will happen is a rights hearing determines whether or not you're indigent. So if what the law considers you to be indigent, that means that when an enforcement is pending, because an enforcement motion or hearing is quasi-criminal, which means that there is an element to it that allows me to place you in jail if I were to find that you violated the order and hold you in contempt. By law, if you're considered indigent, I have to appoint an attorney to represent you, okay?
Mm-hmm.
What's going to happen, Attorney Holland is going to ask you a series of questions for me to make that determination, okay?
Okay.
All right, go ahead, Attorney Holland.
I'm sorry, Judge, I wasn't prepared to ask the questions.
I can ask them. Okay, Ms. Ellison, where do you currently work if employed?
Self-employed freelance, Uber, Lyft, Grubhub, Walmart, Spark.
All right. And this could be a rough estimate. It doesn't have to be an exact amount. How much do you say that you bring in monthly from all of your jobs?
$700 to $1,100. So it depends on like how often I work. So $700 to $1,100.
Okay, and that's on a month.
Yes, ma'am, monthly.
All right. Where do you live?
In Cedar Hill.
Who do you live with?
My grandparents.
All right. What bills do you pay, if any?
My car note, my car insurance, my cell phone bill, and sometimes the light bill.
Okay. How much is your car note every month?
It's $404.99.
What about your insurance?
They just went up to, I'll say $100, about $110.
Okay. What about your cell phone?
That varies to just say $90.
And lastly, the light bill. I know that fluctuates.
Right, $300. Last month it was $300.
What about any savings account or anything?
I did create a savings for my daughter, but I don't have a personal savings.
Right. Attorney Holland, do you have any further questions for Ms. Ellison?
Yes, ma'am. Do you receive child support?
Yes.
And how much do you receive per month?
It varies. Before, I'm not sure if, as of this summer, that child support linked his place of employment, but before then, it was when he paid it. And then that number was never the same. It fluctuated. So I can say as of August, I get $200 a month. Since September, I've been getting $200 a month.
Okay. And besides child support, is there any other income that the judge has not covered that you receive?
That's it.
Okay, Judge, that's all I would have for this witness.
Thank you. So according to your testimony, Ms. Ellison, the court is going to find that you are indigent, and the court is going to order that you're appointed an attorney through the public defender's office here at Dallas County. So what's going to happen is I'm going to prepare an order. My coordinator will have it sent out to you and Attorney Holland. It will have the contact information for the attorney, It'll have their phone number as well as their email address. You're responsible for reaching out to them, okay? Make sure you follow any directives they give you, any information that they request from you. You are doing that, because on the date of the hearing, which is January the 5th of 2026, okay? You're going to have to proceed on that day. So if you don't give your attorneys anything, they won't have anything to present for your defense. You understand that?
Yes. So that I'm now clear, what is the word indigent?
Indigent, it doesn't mean that you're poor or anything like that. It means that you do not have, what the state of Texas considers to be indigent is you make money under a certain amount. So the best way to look at it is minimum wage. Someone who makes minimum wage earnings or that will be what's considered indigent.
Okay.
So according to your testimony, your income at max is $1,100 a month.
Not monthly, that's if I'm working. So
Yeah, so at max, if you're working, according to your testimony, that would be what you would have. So on the low end, it could be 700, which is well below the minimum wage income bracket, which would make you qualify for a court-appointed attorney. Does that make sense?
okay, so indigent, I'm being appointed an attorney based on my income?
Yes.
Okay.
Yes,
And
ma'am.
because I'm below, what is it, minimum wage? What did you say? I'm below what?
You would be considered at minimum wage or even below minimum wage if you make 700. Like if you're making $700 a month, that's what it would be under the minimum wage bracket for income.
So I have to have a court appointed attorney.
Yes, ma'am. That's what the right hearing is. Now, that's not to say that so in having a rights hearing, I am under an obligation to appoint you one. But if you tell me, Judge, my grandparents want to hire an attorney to represent me and your grandparents are going to pay for it, you're well within your right to do that.
Okay, yeah, that won't be happening. So I guess I'll have to have the court appointed.
Yeah.
Judge, I don't know if she wants to represent herself or not. I know that that's an option too.
I was going to say that you can represent yourself on this hearing as well. It's really your call. Motions for enforcement, just to give you an overview of them, they are very technical motions, okay? So with that being said, if you're going to represent yourself, you're held to the same standard as Attorney Holland here. I know you may not have a background in legal or anything like that, but you are held to the same standard. So you would be responsible for tendering your own exhibits, making objections for yourself, all the things.
All right. I'll move forward with the appointed attorney.
Okay. Attorney Holland, I don't see the return of service back on here for the January 5th date.
January, we just said it about 5 minutes ago with Judge Lee.
Oh, okay. Okay. I got it.
And she ordered her to appear on that date, and it's put in Miss Ellison's order for continuance. She asked for a continuance also. So Judge Lee put all that information in an order for a continuance.
Okay. And the continuance from this January 5th day?
No, from the November 4th date that we already had set.
November 3rd. It was set for November 3rd.
Okay. I see it now. So what I'm going to do, ma'am, is I'm going to swear you in so it's on the record. Although Judge Lee swore you in and gave you an order, I just want to make sure that it mirrors your order, okay? So I'm ordering you to reappear on January 5th. Hold on one second. Let me pull up this time. I'm ordering you to reappear on January 5th, 2026 at 9:00 a.m. here in my courtroom, which is located at the George Allen Courts building at 600 Commerce Street on the 4th floor. It's the district court. So I'm in the new wing of the building. That's Dallas, Texas, 75202. If you fail to appear, a KP's warrant may be issued for your arrest, okay? Do you have any questions about those instructions?
No.
Okay. Do you have any other questions for me while we're on here?
I was needing clarity on just the whole, who do I speak with you, or is this now a question for my new appointed attorney in Ms. Holland, or can I presume to ask you like clarity on the filings, like the court case?
Okay, so depending on the question that you may ask, I may not be able to answer it because I can't give legal advice. So if it's something regarding the pleadings itself that may be a question you want to reserve for your attorney.
Okay. The question was just simply clarity on what Mr. Williams is filing for. Like what is contempt / enforcement? I know it was enforcement of the schedule that we had in place, but I'm unsure on, from my understanding, it's two different filings. So it's contempt and enforcement. Contempt, what is
Okay,
exactly what is
so I can answer those. So whenever there's an order in place, right? Whenever someone alleges that there is a violation of that order, they file what's called a motion for enforcement. Okay, so the motion for enforcement is what brings it to the court's attention that certain provisions of the order has been violated. You follow me so far? Okay, so as a punishment for the violation of the underlying order is contempt. And contempt can come in two forms: is civil contempt, which civil contempt are the attorney's fees and the fines that he would be asking you to pay for him bringing the motion, right? There's also a criminal contempt component, which is why the necessity of the court-appointed attorney, because as a result of violating an order and being held in contempt, the law allows me to place someone in jail up to 6 months or 180 days per violation. You see how serious that is?
Yes. So is that what we are appearing for, a criminal? What did you say?
Well, it's quasi-criminal. That's why I use that word quasi. That because you can be placed in jail, that's the criminal component of it. Does that make sense?
Yes.
Okay. So anything beyond that, you would have to talk to your attorney about, how y'all going to proceed on the motion and all of that. I can only give you the black letter law, and that's what I just told you, exactly what the family code says about what a motion for enforcement is and the consequences that can come as a result of it.
Okay. Would this fall under legal advice? I don't know. So
well, ask it, I can tell you.
It seems like he's guilty of what he's filing for. So is it like, even though we have this current court case, am I able to file the same motion?
Absolutely. Anyone who...
He's guilty of what he's filing for.
Okay, so that part, I have you tell that to your attorney. But anyone who is affected by the underlying order, you are a parent named in the underlying order, you can bring a motion for enforcement. I mean, people have competing enforcements all the time. Anytime a provision has been violated, either party has the right to bring that.
Okay.
Okay.
Noted.
All right. Is there anything further for the record?
I have nothing further, Judge.
Okay. Well, thank you.
I want clarity on the January 5th in-person appearance. Is that I'm so flustered I can't even speak. That's at 9 a.m.?
Yes, ma'am.
Okay. I just wanted clarity on the time. No further questions.
Okay. Well, thank you all. All right. So you all are here today on an enforcement that was filed. Hold on, it's a modification that was filed too. Okay, the enforcement was filed July 14, 2025. Is that correct?
Yes, ma'am.
Okay. And you're referencing a temporary order that was put in place.
Yes, ma'am.
Okay, let me find that 626. Here we go. Okay, Mr. Walters,
Yes, ma'am.
looking at your motion, and I see where you attach the order, but I
Yes.
see where the specific violations.
Pretty much she took them from me on the 8th. On the 6th of June. I didn't see them until September after school started. And she had daily visitations with them from 6 p.m. to 8 p.m. And then I texted her and asked her for the kids. She wouldn't bring them to me. She ignored most of my text messages, if not all of them.
Okay. I'm looking at you all's court order. So on a motion for enforcement is very specific, okay? So in order for me to hold someone in contempt, which is what you're asking me to do, the violations have to track the language of the order, the underlying order. So let me tell you what I mean by that. Do you have the temporary order in front of you?
Yes, ma'am.
All right, so go to page 6.
Okay.
Possession order. You see that?
Yes.
Okay, so who is Kaylin Quinenthia Stewart? You. Okay, so this is your possession schedule. I'm looking for your possession schedule, Mr. Walters. So what it's saying is that the possession schedule that's outlined here, this is for mom's time, and any other time outside of this is yours.
Yes.
Are you alleging that she didn't give the child back outside of this time?
Yes.
Okay, so your motion has to say that. So you have to go one by one and lay out each one of the violations for me in order to hold her in contempt, or even to find that she violated parts of the order. Does that make sense?
Yes.
Because without it, not only do I not know the violation, but more importantly, she has to be on notice of her due process rights. She has a right to receive notice of allegations being brought against her. And without that, she can't properly defend herself in court. So the motion has to be specific with the violations. I don't know your financial situation or whatnot. You don't have to tell it to me. But with motions for enforcement, they are so specific that it may not be a bad idea to consult an attorney. And either one of you can, if you want to file motions for enforcement. It may not be a bad idea to consult an attorney because they are so specific and technical that if they're not done properly as outlined in the Texas Family Code, my hands are pretty much tied.
Okay.
Does that make sense?
Yes, it does.
Okay, so while both of you are here, I just want to encourage you to follow your court order. Whatever it says, even if it doesn't seem like it makes sense or it's enforceable, follow it as the best you can. And there are ways that you can bring a motion before me for me to clarify it. Does that make sense?
Yes.
And from reading your order, just off looking at it, it needs some work. Because as it's written, it's not really enforceable to neither one of you. And if you don't fix it, you'll be right back in here in front of me. Not only will you file a motion for enforcement, she could file one too. Do you understand? You both understand what I'm saying?
Yes, ma'am.
Okay. So as best you can, just follow the court order as is written until it is modified, okay? Does anybody have any questions for me before you all leave?
No, ma'am.
Okay. Well, thank you all. You're
Thank
welcome.
you.
Jeffrey Ermis on behalf of the movement.
Okay, thank you. State.
Alina Franklin with the Office of Attorney General.
All right. Mr. Owens, are you representing yourself here today?
Yes, ma'am.
Okay, would you please announce for the record? State your name.
Daynell Owen.
All right. Would you raise your right hand for me? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
All right. We are set here today, Mr. Owens, on a motion for enforcement or allegations of you violating the underlying court order, okay? So before I can actually proceed with a hearing on that matter, I have to have what's called a rights hearing to determine whether or not you're considered indigent. Because if you're considered indigent by law, I have to appoint you an attorney, okay? However, if you're not considered indigent, you still could proceed today in representing yourself, or if you are requesting an opportunity to hire an attorney, I can give you time to do that as well. Do you have any questions based on what I just said?
Oh, no, ma'am.
Okay. Attorney Ermis, you may proceed.
Your Honor, would you like me to elicit testimony regarding his current income?
Yes.
All right. Mr. Owen, how much do you pay for rent each month?
So my rent is about $1,100.
Okay. And do you actually give someone money for that, or do you have some sort of agreement regarding your rent?
I have an agreement. I do contract work, and the person that I work for also owns the home that I live in. When I get paid, the money automatically comes out of my checks.
Okay. So at least $1,100 each month comes right out of your check.
Correct.
Okay. And how much is your car note?
Well, it was $100 a week. I just had to get rid of the vehicle because it stopped working on me. As a matter of fact, they literally just picked it up just now.
Okay. So your testimony is currently you do not pay anything for a car note.
Not as of a few days ago, no. But I was paying some before.
Okay. And so this past month, I'm going to assume that the $1,100 was taken out of your check from your boss.
Correct.
And then how much for the month did you get in excess of that $1,100?
To be quite honest with you, sir, I'm not sure what it was. However, I will say this. I do know I made, as a matter of fact, you know what? Give me 1 second. I can give you a quick estimate. I'll go ahead and explain. So the type of work that I do is contract work for a company called
CGL. Your Honor.
Sustained. Mr. Owens, just answer the question that he's asking of you, okay?
Okay. Let me see. You said last month? What's the question?
That's where I started at. Yes, sir. I'm trying to help you figure out how much money you make.
I'm sorry. I'm looking at a calendar here. I have everything written down in front of me. I would say I made maybe about $1,800.
Okay. So when we add that $1,100 back in, that becomes $2,900, correct?
Right.
Okay. So $2,900 per month. Then you have no car note. Do you have any
Not
insurance?
anymore at the moment.
Okay. Do you have any insurance that you pay?
No, sir.
Okay. And how much do you spend on groceries each month?
It depends because I also help out with another child of mine that I had. For myself, maybe about $300. Maybe.
Okay. And for that other child, are you under a court order to make payments?
It is.
Okay. Are you making those court payments?
I pay mom directly. I don't go through child support, but I do give her money.
How much do you give her?
It just depends on how much she asks. But I was paying I was helping her out with my daughter's physical therapy, and that was about $300 a visit. Yeah.
Okay, so $300 a month there. Is that what you're saying?
Yeah.
Okay. What other bills do you have?
My phone bill, which is $130. And then because my vehicle was my work, I had to pay for gas on a weekly basis, which was maybe about $150 a week.
Did you say $150 a week?
Yes, ma'am.
Okay. Is that it?
That I can think of, yeah.
I pass witness, Your Honor.
Okay, Attorney Franklin.
No questions, Judge.
Okay. Attorney Aramis, is there anything else?
I'm sorry, Judge. I would ask one more question if I may.
Go ahead.
When was the last time that you made any court-ordered child support payment to any parent?
I'm not entirely sure, sir, as far as to answer the question directly. I'm not entirely sure. Like I said, I have helped her in between the time since then, but I guess you all would consider that as a gift and not a payment.
Do you think it's been more than a year?
Yeah. As a matter of fact, the last time that I gave her $500, she put it towards child support. It was in a favor that she needed to get her car out of the impound.
Was that Catherine or was that the other mother?
No, that was Catherine.
Okay. I'll pass the witness, Your Honor.
Okay. Is there anything else further from this witness?
Not from me, Your Honor.
Okay. Attorney Franklin, nothing?
Judge, no, the state doesn't have any questions for the witness.
Okay. So at this time, Mr. Owens, the court is going to find that you are not indigent. However, I will allow you time. I will reset this hearing to allow you time to find an attorney should you choose to want to hire an attorney. Would you today represent yourself, or would you like to have the opportunity to hire an attorney?
It would probably be smart, but I'm going to be honest with you, man. In the current situations that I've been in here lately, I wouldn't be able to afford one.
Okay.
Your Honor, if I may, I do think a relatively short reset, because my client did ask about making a settlement offer to Mr. Owens, and I think 30 days to explore that, depending upon the court's calendar, would be appropriate, instead of just asking for Mr. Owens to be put in jail today.
Okay. Yeah, I have the first available is December 1st.
Let me look at my calendar if I may.
Yes. Mr. Owens, are you available December 1st?
Yes, ma'am.
Okay. So I have the times that I have available left are 10:30 and 11 o'clock.
Can we get the 11 o'clock, Judge?
Sure. Mr. Owens, does the 11 o'clock work for you?
Yes, ma'am.
Okay. Does December 1st at 11 o'clock work for the state?
Yes, Judge.
Okay. All right. And this is an in-person hearing? Is that correct, Attorney Aramis?
Yes, ma'am. I'm so sorry.
No, it's
Yes,
okay. Okay. Mr. Owens, I'm ordering you to reappear here in person on Monday, December 1st, 2025 at 11 o'clock a.m. to my physical courtroom, which is located in the George Allen Courts Building at 600 Commerce Street on the 4th floor of the new wing, Dallas, Texas 75202. Your failure to appear could result in a KPS warrant being issued for your arrest. Do you have any questions about those instructions?
No, ma'am.
Okay. All right. Is there anything further for the record?
There's not, Your Honor. Thank you.
All
No,
right,
Your
thank
Honor,
you.
thank you.
And I won't see you before the Thanksgiving holiday, so happy Thanksgiving to you.
You
Happy
too, Judge.
Thanksgiving to you as well.
Thank you. Have a good day.
May we be excused?
Yes, you may.
Appreciate you.
Which case are you here on?
The case number that I'm here on is DF 23-16538. I had filed a motion.
Okay, let me see where you're supposed to be. Okay, Don and Anthony Wilburn.
Yes, she sent me Brittany King said I was supposed to be in this court, and she gave me the Zoom. Yeah, the Zoom ID, and I put it in, and so I'm here. I just been waiting.
Okay, so it looks like your hearing this morning was reset.
Oh God, the other one was reset from the 2 weeks ago. It was reset, and they reset it to here today.
Yeah, what I see in my notes is no appearances were made at the October 21st status hearing.
No, I was on a call waiting. I waited for an hour on a call for that call, and then I called into the courts, and they said, well, that was reset to the 27th. I said, no, I have a preliminary hearing that was for the 21st, and then I was supposed to go a week later and come today. And they said, well, no, the judge had reset everything to the 27th, so appear on the 27th, which I did. So I just done what they had told me. That they said it was reset on then, because I had called in after and I got it. It's Zoom, so I got it. I took snapshots of it that I was on the call waiting, and no one showed up and stuff. And so I had called into the courts, and they said the 255th courts, and they said that to the clerk, and he said, oh, the judge here reset that to the 27th. So you're not gonna go today, but you're gonna go in on the 27th. So make sure you're there. And I made sure I was here. I was here at 9:30 waiting and stuff, and then I went on, and I just been waiting to be called.
Let me ask you this. What's the Zoom code that you have?
Okay.
Mine, the conference that you would have had would have been in front of Judge Lee.
This is the Zoom code that you talking about for today, or the one that was on Tuesday?
The one that would have been on the 21st. Yes, sir.
Yeah, the 21st, it was 915-9144-2553, and that's the one I attended on the 21st.
Okay, so I don't the Zoom code is correct. I don't have any notes in here that says that you showed up. So what I'm going to do is I'm going to
Let's see if goodness.
have you been talking to Brittany? Have you been talking to the coordinator via email?
I talked to her via email, and she had sent me this. This what I'm reading it out of her email that she sent me, and then she sent me I had called in on the 21st. Again, I waited an hour. I was on a call actually there at 9:15 waiting for the Zoom call. I had waited an hour after the meeting because I said maybe they'll call me sometime in it. No one ever called me, and so I called into the clerk office, and they said no. Your meeting has been it's been they changed it to they said I guess you the judge, I don't know, but it said it was changed to the 27th, and I said no, I'm supposed to have initial contempt enforcement status conference, and then I have my contemporary enforcement hearing this on Monday, and they said no, the judge pushed everything to Monday the 27th. I said okay, I guess I'll attend on the 27th at 11 o'clock. I said to him, he said yes, 11 o'clock. I said I'll get on the call early today so I can make sure, because I make sure I'm on early. So if you call me as the first case, I'm on the call. But you know, you just saying something to me now and stuff, and then they saying they're changing it again. But I was a judge. I was on that call Tuesday on 10/21. I was on a call, definitely. I got snapshots to validate it.
Hold on 1 second. One second. Did you receive an email to exchange exhibits?
No, she told me. Brittany had said, because I was asking, are you sure? And she got this is the thing she said, do not reach back out to me as as there is nothing else for me to do. It's in big bold letters underlined for me to do at this time. Be sure to serve all parties, which I did serve all parties the papers, and I've done everything.
Let me ask my question. Let me ask my question again. Did
Sure.
you send any exhibits? It's just yes or no.
Oh yeah, I had attached them I attached them already. The exhibits is already attached.
Okay, so this is what we're going to do. Send an email to Brittany right now, and then we're going to reopen it and get you a new status conference date. And that way we can move for you to get another date with me today. So from what I'm seeing in the system, that the case was dismissed because you never submitted any actual exhibits. So
There's 4 pages of exhibits. They gave me the when I was there, they said you might want to copy some.
Hold on 1 second. I understand your frustration, okay? I can't do anything about something that I didn't have any notice of what was going on. It just came to my attention this morning. So go ahead and send an email to Miss King.
She told me don't email her no more.
She told you don't email her anymore, referencing that because there was nothing else she could do after that point, because Judge Lee is who would need an email from her that shows your exhibits. So let's go ahead and do that right now, okay?
But can I ask you a question?
Go ahead and send it.
No, I'm gonna send it, but when I filed the motion, I attached the exhibits to there. So she should have the exhibits because I attached them.
I'm glad that you said that. Any exhibits that are attached to a motion, I cannot consider because those are not admitted into evidence. So I cannot consider anything that's attached to a motion as an exhibit outside of a special motion, like what's called a motion for summary judgment. Then the exhibits are required to be attached, but the motion that you filed doesn't allow me to consider any exhibits that you attach. So you would have had to detach those exhibits, or you could have left them attached to the motion, but you would have had to send them in a separate email. Does that make sense?
The whole course setting is it's off base and stuff, and I'm considered one that got a high education, and it's so many loopholes in the course system, and so many it's tough, for a parent that really love their kids and give a really good effort. I love my kids unconditionally, and I've done so much for my children. And to go through all of this, it just, and they'll tell me, black men will tell me, you should just walk away from your kids. She giving you all that stress. You don't took very, and I didn't understand it at first, Judge, but now I do understand it. I understand why some men walk away, but I love my kids too much to walk away. But it's so hard. It's so hard. It feel like you're in hell, actually, and I'm a Christian that love my children like God required me and take care of them. But it just seemed like you're in hell when you going through all of this stuff. It don't seem fair. And it's not fair. It seem it's not fair.
I understand your frustration, especially when you're representing yourself, trying to navigate the court system. That makes it a lot more difficult. Okay, so
I wish I had money to have an attorney, ma'am.
Wilburn, hold on. I have to get to this next hearing. So what I need you to do is to go ahead, log off, send the email to Ms. King. She's going to reinstate your case so we can push it forward. So there's no more delay. Okay.
Okay, she kept going back and forth the last time on I got this date and how do you feel about it when
I called her in the courtroom, so she's listening to me.
Right, and good. I don't lie to no one. And I had kept picking a date and and she'll say, oh, that one is Phil. I just want the next available date without going all back and forth. It's too much for me. The next available date that you have available to get me in the courtroom, and I did, like I said, I attended to both of those settings at the proper time before the hearings on the 21st and today, and now I'm hearing it don't been reset and stuff, and I just would like to go on and get it over with as possible.
That's what we're trying to do. I'm trying to help you. Brittany is right here sitting with me, so she's hearing. I'm looking at her in her face.
Oh, good.
Instructions, Mr. Wilburn, so she knows exactly what to do. She is waiting on your email.
All right, so send it. I don't have to send it. Just the exhibits you want, right?
Just go ahead and send the email, letting her know that you are requesting an exhibit conference, okay? She'll know exactly what you're talking about because like I said, she's sitting right here. I'm looking at her in her face.
All right, then. All right.
Okay.
All right. Thank you very much. You guys have a happy Thanksgiving, okay?
Yes, sir. You do the same.
All right. Thank you.
You're welcome. Bye-bye.
All right. Bye-bye.